Welcome, everybody, to this remarkable opportunity to be a part of a conversation with two of the world's leading jurists. Before we begin, I wish to acknowledge this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we're grateful to have the opportunity to work on this land. The Faculty of Law at the University of Toronto is host to a dizzying array of wonderful speakers and events. But even in that context, today is an extraordinary occasion. It is an honor to have Justice Elena Kagan of the United States Supreme Court and Justice Rosalie Abella of the Supreme Court of Canada join us today. Thank you both very much for being here. With lives and careers that these two distinguished guests have had, I could take up the hour with introductions. I think merely mentioning their awards and honors would take up most of the hour. But I have a feeling that hearing me talk is not what you came for, and I will be brief. Today's special guest is trailblazing Justice Elena Kagan. A bit about her. After clerking and practicing briefly, Justice Kagan began her academic career as a professor at the University of Chicago, swiftly earning a reputation for scholarly brilliance. She then joined the Clinton White House in various roles. On leaving the White House, she became professor and then dean of Harvard Law School, the first woman to hold that post. She was a transformative dean, known for her hard work, intelligence, collegiality, and great judgment. She is credited, with many other accomplishments, with creating a new and positive sense of unity and community at that great institution. Former colleagues describe her as one of the most successful academic leaders they have ever seen. Another trail was blazed next when President Obama appointed her to the role of Solicitor General of the United States, the first woman to hold that post. President Obama then had the excellent judgment to appoint her to the Supreme Court. She is a leader on the court, known not only for her legal insight, but also for her wonderful legal prose. And of course now, no bio of Justice Kagan would be complete without reference to her honorary doctorate of laws from the University of Toronto, conferred this morning. Congratulations. I describe Justice Kagan as our special guest only because it is impossible to think of Justice Abella as a guest. Not only are we all sitting in her room, but we are also sitting in her faculty. She's not just our alum, but a steadfast friend and supporter of our law school. Another honorary doctorate recipient from the University of Toronto, Justice Abella, as many of you will know, has also had an extraordinary life and career. Born in a displaced persons camp in Germany, a piano prodigy, she has, like Justice Kagan, been a trailblazer her whole life. After graduating from U of T, she was appointed about a minute and a half later to Ontario's Family Law Court at the old age of 29. She was the youngest appointment to the bench in Canada's history and was also the first Jewish woman appointed to the bench in this country. To top it off, she was pregnant at the time. She was later appointed to the Ontario Court of Appeal and then the Supreme Court of Canada. Along with a wonderful legal mind, she shares with Justice Kagan a remarkable judicial pen, and she has used that tool wisely and compassionately. I like to say that the only thing bigger than Justice Abella's legal brain is her heart. Thank you both so very much for being here today. The format for the discussion will be that Justice Abella and Justice Kagan will spend about a half an hour in conversation with one another, and then we will turn to the audience for questions. It's a majority student audience. I'm hoping that they will give priority to questions from students, so there's going to be microphones at either aisle, and I would please encourage the students to line up to ask your questions of these two wonderful jurists. So thank you again for being here, and Justice Abella, I will hand it over to you.
Thank you. Well, first of all, Dr. Kagan. Doctor, isn't it? That's what he said, Dr. Kagan. Dr. Justice Kagan. My wrist hurts a bit here. Can you bend down?
Nothing to say about that. No.
We are so excited that you're here. Thank you so much for coming to Canada. It's a great school, and it's a great country, and a great dean.
In a great country.
You know what we call Harvard, the U of T of the South. So I want to thank you for one other thing, which I have learned this afternoon, and that is the way for a Canadian Supreme Court judge to get a standing room only audience in Canada is to be on a program with an American Supreme Court. Where to
Just because you come back here so often, they're used to you.
chop liver?
Yeah. But this is amazing. You have your own moot courtroom.
And I'm still alive.
You're still and I'm just guessing you did not give $1 gazillion to get your name on that door.
No, I cut it off at 1 million. I said, that's all my grandchildren can afford.
You know, just
This is very nice, but the first time I walked into the Abella moot courtroom, I found myself saying, I feel like Fred in Spamalot. I'm not dead yet. So let me start with something which I'm sure you know. We are so riveted to the American confirmation process, the hearings. We watch, we
you did not
pay
give
attention.
any fair warning. You were going to ask you. You know, we talked.
Excuse me, I'm the judge. I don't have to give you fair warning. So we were all glued to our TVs because it's a fascinating thing for nice, gentle Canada to see. But I think I speak for
Do you
every...
have any kind of hearings?
I hear very well.
No.
So let me ask my question, because I think it's on everybody's mind who watched the most recent hearing. Do you like beer?
What was your second question? Seriously, can I ask you, do you have hearings at all?
No, we have the merit system. No,
It's off? It's on? They were laughing. Thank you. Do you have any hearings?
we have kind of a hearing. There was, you won't be surprised to hear, a lot of discussion in this country about whether we should have the American-style hearings. And most of the judges resisted it because our sense was, as you wrote in an article once, people tend to give answers that are pretty anodyne and not terribly revelatory of anything that really matters. But people know you, and there is recognition. I mean, if I walked out on Bloor Street with you, people would say, who's that with Elena Kagan? So you have name recognition, the court has recognition.
Is that a good thing or a bad thing?
I don't know. You have a different culture than we have.
Yeah.
But the question for many of us was, what comes from those hearings that outweighs some of the negative consequences of the hearing? So we started one. We had a very nice judge who did the first one, a really nice guy. He was sweet and adorable, and everybody behaved really well, and they walked away saying, see, we can do this. And then as time went on, they became somewhat attenuated, and now we have vestiges, but nothing like your hearings. Do you think they were?
Yeah, I think it's really hard. I mean, I don't think that they work very well in its current form, but nor would I say we should just get rid of them. You know, I have complicated and mixed feelings about it. I do think we're an important institution of governance, and you know, the senators who are charged in the Constitution with deciding whether any nominee gets to the Supreme Court, you know, should have the ability to take a person's measure, and the public should have the ability to do the same and to communicate their thoughts, if they have any, to their elected representatives who are charged with that constitutional responsibility. So it seems good to me from the perspective of transparency of governance and just people taking their constitutional roles seriously and having an opportunity to see a person and to try to figure out what kind of justice she or he would be. You know, in the abstract, I think that that's a good thing. I think in the concrete, it's a little bit hard to watch any of these hearings and think that they accomplish all that much.
What was it like to go through one?
So, yeah, I had a relatively calm process. I think people kind of knew that I was going to get through. I wasn't one of your more controversial nominees.
What's that like?
But even there, I mean, it's we have lived in our country for some years now in a very divided system. I think people had a high degree of confidence that I was going to get through, but not with a lot of bipartisan voting. I got a number of Republicans, but fewer than 10. I think there were 6 or 7 or something like that. So even a relatively uncontroversial person is still that the expectations were that I would not get very much bipartisan support. And that's been true pretty much of all of us since I think the Chief Justice was the only person who really managed to pick up lots of support from members of the party who did not nominate him. So that's very different from what it was like about 30, 25 years ago. My colleagues, Justice Ginsburg, Justice Breyer, Justice Scalia,
right.
All of these people had strong views, at least as strong as the people who have gotten on the court more recently, and they all got confirmed by votes of like 98-2. Yeah. So something very dramatic in the American political system has changed with respect to Supreme Court justices, and it's hard to figure out how to get back to a system where people get the opportunity to question you and to find out whether you have the qualifications to be a judge and whether you are a person with good judicial values, but then think our job is basically to say yes, as opposed to our job is to fight about you. And it's hard to know how we ever get back there because the court in the United States decides many important questions and questions on which the population is deeply divided. And so people think of the court as we need our person on it. We need our person on it, and that's I think that's bad for the court, and it would be better, I think, if it was all toned down. But I don't know how to get there.
The fact that the country appears to be in a very different place from where it was 20, 30 years ago, does that argue for a different role for a Supreme Court?
Well, I think it's clearly true that this is related to the courts taking positions on many controversial issues. And if the court did nothing on the issues that people feel strongly about, and you can name them as well as I can, there would be less political controversy surrounding the court and less engagement with the court. But my court, like your court, has a responsibility to police the Constitution, police the political branches and make sure that they measure up to constitutional commitments and guarantees. And that's sometimes going to take you into controversial areas. So, is it a reminder that that there is value in judicial modesty and restraint, and in what used to be called the passive virtues? Yes, I think it is, but I think it's inevitable that my court, like your court, is going to have a voice in some issues that members of the public care about.
Now, what limits are there to your role as an individual judge? You have a set of values, you have a judicial philosophy. How do you implement that? How do you take the skills you had as a Harvard dean, a consensus builder, and apply them in a setting where it may not be as conducive to having people open to coming together on a compromise. So the first position is it's good at this time when everybody is so polarized to have an institution that brings people and issues together. Is that possible, though, when you're in an institution like yours where people are independent-minded, strong, and have very set views?
It's possible sometimes, but it's not possible all the time. And it's not possible all the time for exactly the reason that you just mentioned. These are 9 very smart people who have been around the block once or twice, who have their own views about lots of questions that come before us and about judicial philosophy and method that leads them to give certain answers to even new questions that come before us. But all that said, I think it remains possible for people to listen to each other. I think we actually do a pretty good job on the court of doing that, of actually paying attention to what each other is saying, and to trying to reach common ground where we can. And sometimes we do it better, and sometimes we do it worse. But I do think that there is room in a judicial system, even a judicial system that necessarily decides on many important matters because of the important role that it plays in the constitutional structure. I do think there's room for people to listen to each other and to try to find common ground and to try to find areas of compromise. And I think that the way you do that, no surprise, is the way you do it in any institution. Is by, there are many big questions that people disagree about, and usually the way to find agreement and the way to find consensus is not to keep talking about those big questions, because you're just going to soon run into a wall, but to see if you can reframe the question and maybe split off a smaller question. And so, the way to reach compromise and to gain consensus is to take big divisive questions and make them smaller and less divisive. And when people really want to do that, it can often happen.
But some of the issues that you've been dealing with, like union checkoff, gay marriage, really don't lend themselves to being reduced to smaller components?
Yeah, I mean, some don't, not with respect to any particulars, but some issues look pretty binary, and when they have that structure, it's awfully hard to get 9 people who have different judicial philosophies, who have different ways of approaching constitutional issues, to get together and decide things. But I will say, I think that's clearly true, but I think that there's a greater area than many people think for consensus building. So for an extremely unfortunate reason, we were an 8-person court for almost 2 years, almost 2 terms, and that was because Justice Scalia died in the middle of the term, but before we had decided very many cases for that term, and that seat was unoccupied almost through the next term. So there were 2 whole years of the Supreme Court's life where we were an 8-person court. And there's a reason why appellate courts don't have an even number of people, right? And that reason is because there are some questions that it's like, how do you do it? If it's an even number of people, we're going to be tied. What are we going to do? And but all those 2 years, we tied. When we do tie, the way the U.S. Supreme Court works is we do something like it's 4-4. We can't progress any further. It's affirmed by an equally divided court, and we just send it back down, and whatever the decision below was stands. And I think people were really scared that in those 2 years, that was going to happen quite a lot. And it turned out it happened almost never, that all of us were really committed to trying to find common ground and really committed to to operating in a way that people didn't think that the court had ground to a halt and that the court had stopped working. And so that meant, on a fair number of cases, we did our usual thing. We went around the table, we expressed our views, and then we discussed, and we got to the end, and it looked like we were 4-4. And then the Chief Justice would say, well, let's keep on thinking about this, and let's keep on talking about this. And whether it was that day, or we would go back to our chambers and try to figure out ways to move forward, we almost always did. In that position where we had to, because we felt if we didn't, it would look to the American public as if the court had ground to a halt. Where we had to, we decided things, and we found ways to reframe questions and to break off smaller questions from bigger questions and to reach agreement. Now, some of those agreements were a little bit silly. It was like there was this big question and everybody needed to know the answer to it, and the courts were divided, and it was really important. And we couldn't really decide it, so instead we decided some other thing that actually nobody cared about. So that was true sometimes, but it was also true that sometimes we did really good work when we did it like that, where we had to keep thinking, and we had to keep saying, is there a way of reframing this where it's not like half the people think it's great and half the people think it's the most horrible thing in the world. And especially in a divided time, I think that there is incredible value to the court trying to do that, trying to find places where it's not that half the country gives you a thumbs up and half the country gives you a thumbs down. And when we had to, we did it. Now, it's a lot harder to do that when you're 9 people again. Mm-hmm. Because when you're 9 people again, you go around the table and, we don't decide many of our cases 5-4. I mean, I think everybody outside the United States, maybe some people in the United States, thinks that that's how we do our whole job. 50% of the time, we're unanimous. It's really in a very small percentage of cases where we look deeply divided and are deeply divided. But those cases are often cases that matter and that the American public cares about. And on those cases, when you go around the table and it's 5-4 rather than 4-4, it's hard for people to say, let's keep talking until we can reach some greater consensus. It's hard for the people, certainly the people, I know for me, if I'm in the 5, it's like, we're done, right? But I think that we are also aware, we should be aware, I think often we are aware, that there's value to building bridges, there's value to building consensus, there's value to not seeming and not being politicized. I don't think we are ever politicized in the way some people might think, but certainly we sometimes appear that way to the American public, and there's lots of value in not being that. And if that means that we go back to our offices and think harder about how we can find areas of agreement, rather than, I think that that's a good thing. Sometimes it won't be possible.
Most of the cases that you talked about where there is a 5-4 split, as you say, are the ones that the country cares about the most.
Yeah, I mean, not all of them.
Well, but they tend to be constitutional cases.
Yeah.
And part of what looks to the outside is happening is that there are 2 different cultures in the way constitutional law is approached. So you have something like our living tree that grows with the times. You have to stay top of it. There is originalism. There doesn't seem to be a whole lot of move between the 2 groups. There are the levels of scrutiny that seem to be applied in odd ways. Korematsu was subject to strict scrutiny. It's not clear where all of that takes you. The philosophical divide in constitutional questions, about what the role of the state is, it feels profound from the outside. And if you slice and dice so that you're only doing the narrow, can it be said that you are subject to the criticism that you're not doing what the public needs you to do? Or is it a way of saying, look, you also need us to retain our legitimacy, and this is the way we do it?
Yeah, well, let me split that question into two parts. So the first part, you gave a kind of analysis of why it is that we're sometimes divided on cases.
How it looks, reading the judgments.
So I think that this is basically true, that you said it has to do with different views of how to approach our Constitution. And I think that that's right. I mean, I think that this is, sometimes people think, oh, they're politicized in the same sense that Congress is politicized. There are Democrats and Republicans in Congress, and then there are Democrats and Republicans on the court, and they're kind of doing the same thing. And I completely reject that. But, it's not as though we're acting in a partisan kind of way, like what's good for my party. I just don't think that that's the way judges think generally, and I know it's not the way that I think or my colleagues think. But I do think that we sometimes mirror in constitutional cases divides that exist elsewhere in Congress and among the American people. And we do that because we do have very different approaches to the Constitution. So let me compare that to, for example, statutory interpretation. We will have super important statutory interpretation cases, and also cases which have a kind of political valence, if you know what I mean. I mean, you're interpreting a statute in a way that the left part of the American public will like, and not the right part. The liberals will like, and the conservatives won't, or the conservatives will like, and the liberals won't. And notwithstanding that, we actually have achieved sort of amazing consensus on statutory interpretation, whichever way it cuts. Sometimes it cuts for conservatives, sometimes it cuts for progressives, whichever way it cuts. And the reason we are able to have that kind of consensus is because we have a shared view of how you do statutory interpretation, with maybe an outlier or two on each end of the spectrum, that almost all of us basically approach statutory interpretation questions in the same way, ask the same questions about how to go about giving meaning to a statute. And that produces a set of results that cannot easily be said to be like, oh, the conservatives did the conservative thing and the liberals did the liberal thing. We just don't do that. But when it comes to constitutional cases, people can look at us and say, oh, look at that. The people who were nominated by Republicans are doing one thing, which tends to be the thing that conservatives in Congress would agree with, and the same on the other side. But I think it's because we just have different understandings of how to interpret the Constitution.
And that's my question.
Yeah, and that's not, I mean, this is something I think, you tell me, I think is different from this country, is that there are two very different views of what you're doing when you're doing constitutional interpretation.
You have two different views, and the question is, since you have a consistent approach to statutory interpretation, which I suspect is like ours, what was the intention of the legislature, what did the words mean? But when you're talking about constitutional law, you're talking about the fundamental values of a country. They're aspirational. And that's where you have to have, I think, in a court, and most courts around the world have an approach. They may disagree on how it's to be applied in a particular case, but they have an approach.
Right.
Yes, we can have international law. Yes, we can have comparative law. Yes, the government has to justify its intrusion in a proportional way. So we have We have a philosophical approach that is unified.
Right, so that makes life easier for
Much.
you.
Much.
Because we don't. We have, and there's lots of subtlety and lots of nuance that I'm going to ignore when I say this, but we generally have two approaches. One approach, let's call it originalism, is this approach where you look to what the drafters of the Constitution thought when they wrote those words down.
Like statutory interpretation. What was the intention of the legislature?
The original public meaning is what it's called, and it's like, what did people, with those words, what did they mean then? And the then is 1789, or the then is, 1868. That's basically the two alternatives, 1789 for most of the Constitution, but 1868 for the important equal protection and due process clauses that came about as a result of the Civil War. And there are different ways of doing originalism, and some people differ even within the originalist camp. But in general, you're basically, it's a historical inquiry, which asks what they thought, what they understood at a particular moment in time when the constitutional provision came into effect. And I think, unlike in this country, that is a very serious mode of constitutional interpretation in the United States.
It's also new, isn't it?
Well,
it wasn't there before 1982 when the Federalist Society was developed, because you often had very different approaches until the markers were put down, and then it became a divided approach to constitutional law.
Yeah, I would say if new is within 50 years or so, it's new. It's 1970s, early 1980s, something like that was when it really developed. And I have to say, it developed, I think, in response to some serious concerns about the other approach. All right, so the other approach is, sure, we look to the original meaning of these provisions, but that doesn't tell us everything. First off, it's often hard to figure out, and even if you could figure it out, in the words of John Marshall, our first great Chief Justice, this is a constitution we're expounding. It's not meant to be frozen at a particular moment in time. And so we also look to historical traditions. We look to sort of history, not just at one moment, but over time. We look to how precedent has developed. And depending on, this too, there are many nuances, many subtleties. People differ in the way it's done, but some understanding that things change and values change in a society, and that's reflected in its history and its traditions and its precedents. And I think originalism grew out of a sense that mode of interpretation, which I'm not an originalist, so I associate myself more with looking at the broad sweep of American history and with
Snyder. Is that the case that kind of started the whole approach to history? Snyder, 37? Maybe I'm wrong. It's okay. It's been a while since I've taken it.
But I think that there was a sense that approach was not disciplined enough. It was, you could make up anything. And a bunch of judges would get together and was like, well, how do we think our society should look? And do something that didn't seem very law-like to people, and that seemed both contested and contestable.
Which brings me to one of the other things that you see in the divided court, and that is, okay.
But we're having such a good time.
Time for questions. If you want to stay for another hour, you're both.
Justice Abella told me that she was going to ask me where I got my haircut. And I think that I was misinformed about the nature of this conversation.
So the divisions in the court bring me to the role of the dissent and the tone of some of the dissents. Because they are such high-pressure areas where people are fundamentally divided on the court, about what society should look like. There is language that creeps into some of the dissents that says things like you're making it up, that says who cares about precedent. I thought your dissent in Janus was fabulous, where you said what was wrong with the boot in 1977. That worked. Why are we changing it now? And you had a judge who kept inviting people to challenge a boot in the courts. So your tone was strong, but it was civil. That isn't always the case.
Some people might disagree even on that, right? I mean, I try to not step over certain kinds of lines, but sometimes people read back to me lines, years later, they read certain lines back to me, and I think, maybe I should have left that one on the cutting room floor, right?
But you do worry about it.
I do.
It isn't clear that everyone does.
I think most people do. Look, Justice Scalia was the greatest writer in the modern U.S. Supreme Court, but he had a sharp pen, and he called them like he saw them, and then I can do the same thing, and other people can as well, and. We probably, the Canadian niceness thing is...
if you're nice, they give you a room. Do you have a room?
But, but I think you said 5 or 10 minutes ago, you said something like, there's some things you can't settle on, there's some things you can't compromise on. I think that there is that is true, not always true when you think it's true, but sometimes true. Where that is true, I think especially in, again, a pretty polarized time, a pretty divided time, a time where you hope that the institutions of governance find ways to bring people together rather than to drive them further apart, and where you fear that they're not accomplishing that objective very well, that in such a time, we step back, we take 2 steps back before we publish a really acerbic dissent or a really acerbic majority opinion. Because these charges and countercharges go both ways when this happens. So you tell me, are people just more polite on the Canadian Supreme Court?
Most. My concern about the tone issue in the American Supreme Court, and has been for a long time, is it has a supply-side impact on the rhetoric other courts use and the rhetoric lawyers may feel is appropriate. And so when it happens on our court, we're very conscious and try really hard to see if we can be persuading colleagues, or they try to persuade us. Can you take that out?
Yeah. So we do have sometimes people will call each other and say, listen, could you take out the sentence? Could you take out this line? And I think almost always people do. But we have a pretty high bar for when those calls are made. So there is even worse than you see, believe me, because things do. I think it's very, very rare that such a call would be made and the person would say, no, this is absolutely integral to what I want to say, so I'm going to keep it in exactly as written. I think almost always people change it, people drop it, but probably our bar is higher for what counts as out of bounds.
Can I ask you one more question? Do I have time, Dean, for one more question? So, Solicitor General, scholar, Dean of a law school, jurist on the Supreme Court of the United States. If somebody said to you, Justice Kagan, you've done so much in so many areas, what would you like people to see as your legacy? What would your answer be? Other than our friendship.
That's very important to me. Yeah.
Me too.
Well, that afterwards,
Okay.
all right? All right. I can answer that question for jobs I've had. You can say to me, what do you hope your legacy was as Dean of Harvard Law School, and I could give you a reasonable answer to that question. I can't answer that question for this job. I mean, I'm curious whether you can. I feel as though, this is my beginning of my 9th year, so it's not as though I'm a rookie anymore.
9 years?
Yeah,
Rookie.
Yeah. I think I was going to say something like that. Like
Not a rookie. Very old, in fact.
How many years?
3 years left.
How many years?
I've been a judge for 42 years.
How many on the Supreme Court?
15.
Uh-huh.
Still good. You want to know where I get my haircut?
So I'm going to say I don't want to think that way about what I'm doing now. I think I want to do it case by case, sitting by sitting, year by year, try to figure out, I think you have to reflect a little bit on where you've been, where you're going, but I don't want to say this is how I want to be remembered. For me, that would deprive me of the ability to take it a case at a time and to really try to think in that case at that moment what's the right answer. And I'll let the legacy stuff take care of itself.
It will. It will. Thank you. It was such a pleasure.
Those are hard questions. It's not over yet.
We have 15 minutes for questions. There's a mic on either eye.
You
and I would
were
encourage
great.
you to come forward with your question. That's great. And if anybody has mobility issues, we can get a mic to you as well.
Yes. You go ahead.
Oh, okay. So I wrote out my question just to make it coherent. So, Justice Kagan, do you think that, given the duty of a judge to apply the law impartially and to some extent unbeholden from public opinion, that the politicization of the federal hearing process does more harm or good?
Well, that's kind of Justice Abella's first question. We could just go back to the beginning and rerun this tape. Yeah, I think I had. I said what I had to say about that. Yeah. Can I say that? Is that like? Can you want to?
You can.
Okay.
Thank you very much for coming to the law school to speak with us today. I almost regret to ask this question, but I feel like I have to just because...
we're in trouble now.
You're in trouble.
They
I'm not.
have to ask the question.
just because
The great thing is I don't have to answer it. Like,
And
as
you're
you just
leaving
saw.
town. So.
I and many of my female classmates, as well as my professors and people that I know in the legal profession, watched the hearings involving your colleague, Justice Kavanaugh, with a little bit of pain in our hearts. I'm wondering what you think the role of the Supreme Court is and how it can be considered legitimate in its treatment of women who have experienced violence when you have not one but two justices who have been leveled with credible accusations and the appointment process has put them forth.
You were right. You should not have asked me that question. And I'm sorry to, say that, but, there are some questions that I'm a part of this institution. I care about it a lot. I care about my colleagues a lot. And that's something that I'm not going to be talking about.
Okay, thank you. I have a backup question. It's totally different.
Okay.
Okay. What do you see the Supreme Court's role in the context of the current Florida recount and in light of some of the controversies that have happened in the past?
Oh, I don't know. I mean, I don't know if anything is going to get to us or in what context it will get to us. These questions about how the election system works in the various states are always very complicated, in part because 50 states have 50 different ways of running their election systems, and they are a combination of federal law and state law. Federal law, which the Supreme Court does have something to say about, state law, which it does not. So sometimes we get involved in these questions, and sometimes not at all. Sometimes even if it's a question for courts, it's actually only a question for state courts. And so there are all these complicated situations about, is this a question for judicial resolution at all, or do we let the political processes kind of take care even of very politically, even of or especially of politically controversial issues about how the election system is running. And then even if it is something that a court might have something to say about, because in the end you need somebody to make a decision, as I said, a lot of the time it's a matter for state law rather than for federal law. So I don't know if anything will ever get to us on any of this. I mean, in general, the court has had a lot of work to do in the area over the last number of years about whether certain kinds of election systems are consistent with the federal constitution. Things like voter ID laws, or any time a state changes its election system, somebody can come forward with a federal constitutional claim about it. And so we've run a pretty
Depressing.
thriving business in trying to figure out what states can do and what states can't do with respect to structuring their electoral systems. And they're very hard because there are thousands of permutations, right? Voter ID system, what kind of voter ID system, where do you get your IDs, where do you, how easy does it have to be made to get IDs? Do you have voter IDs?
We're not as strict as you are.
Well, I would say you're not as strict as some places the thing about the United States is that it's like 50 states do things all kinds of different ways. In our country, the question of race in the electoral system is something that constantly rears its head. In part as a matter of constitutional law, in part, or so it used to be, as a matter of statute, the Voting Rights Act. We recently had a very important case, which I wound up in the dissent on, striking down a provision of the Voting Rights Act, which served, I believe, as an important protector of minority voting rights. We do a pretty healthy business in trying to figure out what is legitimate and what is not in a world in which it just seems that there are just so many variety of ways for political actors to construct electoral systems, some perfectly legitimate, some not.
Thank you very much.
Thank you, Justices. Justice Kagan, other than your haircut and possibly how Justice Bader is doing after that fall, my question is in relation to your comment about the role of institutions of governance like the Supreme Court being a force for good and bringing people together in times of discord and divisions. And I think this is, in recent history, one of the times when I think the American populace has been quite divided.
I want to say something. I know you're getting to a question, but I want to say something just because of the way you framed that. And I think, I did say something quite like that, but I want to make clear that this is all in the context of you have to do your job, right? Your job, and maybe this is one of the things that you were saying, that your job is deciding legal questions. And deciding legal questions that people need answers to. And so we're not in the business of bringing together a fractured American public. I do think that there are ways of doing your job, which is thinking about law, interpreting law, applying law, resolving legal questions that are more or less conducive to which more or less exacerbates divisions within the country and and that is not inconsistent with the judicial role to think about such things, to think about the context in which we're operating. I think that we should want judges to do that.
There was a debate, if I could say, that this is the point that was made when Roe v. Wade was decided. And there were those who said it should have come not from the court. It was something that should have come from the ground up, and the government should have made sure that this was legislation rather than judicial fiat. And that's an open debate. I know that one of your colleagues feels very strongly that it should not have been done by the courts. And there are others who say if you hadn't done it, we might still be there and waiting. So it's either way, there is a division in public opinion. And I guess you just sometimes have to choose which side of the division you want your judgment to fall on.
And I guess following up on your comment, are you hopeful for then the judiciary's role and the Supreme Court's role in this time to maybe bringing people together is too strong language, but to be a force for consensus in these fractured times?
Yeah, again, I don't want to say that we should think of our primary mission, force for consensus. I think primary mission is to decide legal questions, to interpret, apply, think about the law. But am I hopeful that as we do that, we recognize that we should not pour fuel on the fire, and to the contrary, that we should try where we can, consistent with our primary role of law interpretation and law application, where we can, of helping to build bridges across some of the divides in American society. Yes, I'm hopeful of that.
Thank you.
I also wrote down my question. You've touched on this a bit with the other questions and through your conversation with Justice Abella, but I was wondering how the Supreme Court has had to navigate concerns about remaining nonpartisan in the eyes of the public, especially in the face of increased politicized rhetoric from the nomination process all the way through confirmation.
Yeah, I'm feeling a little bit as though I'm repeating myself. Clearly, this is the question of the day, right?
I think maybe I'm more curious about you, like you said, you do your jobs, you interpret the law, but when you come all together, is there a sense of how will this be perceived by the public, and does sort of politics ebb in to the everyday job as it seems to have in the sort of context surrounding the job?
Yeah, so if you were a fly on the wall in our conference room, I think you would find that 98% of the time, we talk in the way you talk when you're in law class. We talk about the law. We talk about how to interpret the law. We talk about decisions that the court has previously announced, what they mean. We talk about history. We talk about precedent. We talk about all the things that you talk about when you are facing a hard legal issue. So that's what we debate. That's what we discuss. These bigger concerns about institutional legitimacy, about the way in which the court can either do something that appears to others to be politicized or not. That's a very small, teeny tiny part of what we do. And I think that that's basically right. Mostly we should talk about law and try to discuss and debate and convince each other about law. But nobody nobody can live in this world and not be aware of some broader context. And I think to the extent, sometimes we talk about that, sometimes it's just the the thing that we all know and we don't have to talk about. But you know, I mean, the American Supreme Court, as I'm sure is true of the Canadian Supreme Court as well, is mostly a bunch of people who are really good at thinking and talking about law, and who really like thinking and talking about law, spending a lot of time thinking and talking about law. So that's what, you know, our primary job is.
I think there's a danger too, if I can step in. This is the whole trick about whether the judges should be catering to, conscious of, taking into account public opinion is a trick question, because I don't know who the public is. I don't know how you gauge public opinion. I don't know that it's even our job to try to figure out what public opinion is, because we're not necessarily a majoritarian institution that has to cater to what the majority in the public wants. So to put it to the court, are you taking into sufficient account public opinion? If you unpack that, you're dealing with shibboleth. I mean, what are you left with except, as Justice Kagan says, you have to do your best to interpret the law the way you think it should be interpreted and hope that over time it will prove to be the right decision. But you can't pitch it to the agitations of the moment. It's just not a stable source of intellectual invigoration.
We have time for one more question. I actually don't know who was at the mic first, so I'll let you guys decide.
Why don't you speak together, both of you at the same time?
I think you might have been first, actually. So why don't you ask a question? Quick question and answer, and then, yeah.
Okay. Thank you, Justices, for being here. Justice Kagan, you talked about how the fact that the court had an even number of justices for almost 2 years, a fact external to the substance of a case, did cause the decision-making process to adjust to that fact. And I was wondering, the fact that the court seems to lack, after Justice Kennedy's retirement, seems to lack a swing vote, someone in the middle. In recent years, it always had someone. Like it had Justice Powell or Justice Stevens or Justice Anthony Kennedy, but not anymore. How important is to have a swing vote, and how is the court's decision-making process likely to be affected by the fact that it no longer has one? Thank you.
There's no question that Justice O'Connor and then Justice Kennedy played an important role on the court, and did so in part. They were two actually pretty different justices, but Justice O'Connor was by nature just a kind of centrist, and she could sort of find the middle of every issue, and that was where she felt most comfortable. Justice Kennedy was actually a little bit different. Justice Kennedy just had an eclectic set of views, so that I'm serious. Justice Kennedy had a very coherent set of legal principles. They were just principles that he shared with some people on some things and other people on other things. So he wasn't like a centrist or a median justice in the way that Justice O'Connor was, but he did keep the court looking as so you didn't know what side it was going to come down on, and both of those people played an enormously important role on the court, and it's going to be hard to know what the new court is like, and I think it's just too soon to tell how we will function without somebody who is naturally in one of those modes. I mean, it could be that somebody will become such a justice, or it could be that they won't. But that even the absence of such a person can just affect institutional dynamics in ways that are hard to predict. So I don't know what will happen, and I think American court watchers will say that this is a really interesting time to think about our institution, because Because for the first time in quite some time, not all the attention will be on one person.
Okay. Thank you. Whoop. No, that's all right. I will project. So thank you so much, both of you, for being here, for your wonderful conversation and your answer to those questions. It's been a real privilege and an honor to have you both here today. Thank you.
Thank you, Ed.